Muted.
Good afternoon, everyone. My name is Colby Duran. I'm a staff attorney and legislative counsel for the National Congress of American Indians, and I'll also be your webinar administrator today. On behalf of NCAI and our panelists, we'd like to thank you for attending this webinar entitled Advancing Trust Reform, New Law to Modernize Trust Asset Management in Preparation for Upcoming Consultations. Before we begin the presentation, I'd like to go over some of our webinar features. First, you should see on your screen the PowerPoint for today's presentation. If during the presentation you experience any lag in the slide transition, it may be a result of the internet connection, so just give it a few extra seconds and hopefully that should update on your screen. Next, we're going to be looking at an example of the GoToWebinar attendee interface, which is made up of two parts. The viewer window, which is on your left, which allows you to see everything that we'll be sharing on the screen, and the control panel is on the right. Within that control panel is how you can participate in that event. So let's take a quick look at that. By clicking the orange arrow, you can open up the control panel. You can see here. Next, from the user, you can also look at the audio pane, look at the audio information. We'll have you only in listen-only mode for right now. Hopefully most of you have dialed in and you're listening through on your telephones. If not, you can also use the microphone and speakers that your computer has as well. If you do want to call in and you want to ask questions at the end of the webinar, make sure that you input your audio pin into the phone. Otherwise, you won't be able to make your microphones live. You can also ask a question by clicking the little hand with the green arrow button to raise your hand at any point during the webinar. And you can also type questions into the questions box on the right-hand side, and we'll be able to get those questions answered that way. Our webinar software allows us to archive all the questions submitted through the box, so if we're unable to answer questions or are able to address the question in the time that we have, we'll follow up with you after the webinar has concluded. And also today, the being recorded, so we'll be able to share that with you via our NCAI channel for those who are not able to attend, and also for future reference. And if you register for today's webinar, we'll make sure that that link is emailed out to everybody. We have 4 panelists with us today. We have Vice Chairman Ernie Sensgar from the Coeur d'Alene Tribe, Brian Gunn from Power Pile, Shuttle, and Burrell, Acting Assistant Secretary for Indian Affairs, Lawrence Roberts, and Deputy Special Trustee, Deb Dumont here. Next, I'd like to turn it over to Vice Chairman Sensgar for his opening remarks.
Thank you. Just want to thank you everyone for turning in today. The trust reform law has been a long time work in progress, and I was so very happy, almost ecstatic when with the signing of the new law. Brian's going to go over the technical aspects of this, so I'm just going to talk about why we're here, or why we worked so hard to get where we're at. I think in early 2000 or late 1990, in NCI meeting in Spokane, Washington, we were introduced to BITAM by Secretary Norton, and almost immediately this created an uproar across the Indian country, wondering why we weren't consulted, where was the tribal input, etc. This stimulated a bunch of hearings across the country, where tribal leaders stood up and voiced their concern about the trust management, and BITAM directly opposing it, asking why create another office? We need the dollars on the reservations. We have issues that needs addressed, and here we are creating another bureaucracy that we have to jump through. Because of that outcry, a task force was begun, and it was tribal leaders from across the nation. I think there was 2 from 12 regions, the Bureau of Indian Affairs regions, and then with 16 alternates, and number of people from Secretary Norton on down. Least was or not least, but and he was Ross Swimmer. And from those meetings, the OST was born, Office of Special Trust, and all through there, tribal leaders spoke out about the need to be a part of any movement that would involve their trust management and their trust assets. And we felt like we weren't being heard. We felt like that the government was doing what they wanted to do and creating this new agency without telling the tribes. The consultation was just appeasement, if you will. We felt like we were going out there and giving our testimony, but okay, we did our job. We listened to the Indians and went back and did what they were going to do anyway. So I guess that was almost from the beginning there was opposition to the Office of Special Trust and the way it was set up. So working at least from the affiliated tribes, we decided to address the trust issues, and we knew that we had to do this with all of Indian country. So with our attorneys and our expertise, we began meetings with the larger organizations like affiliated tribes in the Northwest across Indian country. I think going to the Southwest tribes, Rocky Mountain tribes, Eastern tribes, and holding meetings on trust reform and getting their input. We started drafting a bill to a trust reform bill, if you will, to address those issues. And during this time, Cobell came up and unsettled everyone in the interior anyway. And I got saying what the tribes were saying from way back, that there was total mismanagement of their trust assets and trusts. So here we are with Cobell settled and our attempts at writing a law, and so we had to go back to square one again and start rewriting again, and that kind of brought us to where we are today. Working with Congress is the legislative body has been very, very difficult in these times, and as we would present our law, our bill, we would be attacked by one interest or by one party against the other party. So it was very difficult to get a bipartisan bill, if you will. But through diligence and hard work and talking to everyone, we finally came to this new trust reform bill. Speaking for Indian country and for this Indian boy here on the reservation, and living through this past 40 years as a tribal leader, I was waiting patiently, maybe not patiently, but just waiting for the United States to live up to their trust responsibilities. They have never met those needs in any facet of our lives, from health to education and in between. Trust isn't just with our natural resources or with our trust funds, but our land base, our whole lives out here is a part of that. When I was up in our mountains this summer gathering, and as I was up there, I was telling my grandkids, as I looked over the valleys and the hills, I said, "Look at this." I said these I call Siapis, non-Indians. They came here and they took trillions and trillions of dollars of our natural resources, and we looked at the vast forest that was in front of us, the St. Joe National Forest, the river that runs through it, the waters that they took, the minerals that were in there, the silver and the gold, all those minerals that they took amounted to huge, huge amounts of dollars that helped this great nation. And we were forced into a small reservation, and promises were made. And all we asked was for the government to live up to those promises. That's where that trust responsibility comes into. And that's what Indian country has been saying from time, from people say time immemorial, but since Indian policy began with the government. Live up to your responsibility, live up to that trust. There was promises made. And this trust bill is just a step, just a tiny step in that direction, is to get the United States to live up to their trust responsibility. I hope that tribes take advantage of this. We certainly, it's brand new. We have to work at it, and people have to understand where we're going with this. Deciding on if there's going to be a new assistant secretary and what that job is going to be, how are we going to work with the Bureau of Indian Affairs. We know that it's brand new, and that there's a lot of understanding to go through. So I look forward to working with everyone in a good way, especially Interior, and so that together with the tribes, and this should have been done a long time ago, but together with Indian country, we need to address this trust issue. Thank you.
Thanks very much, Chairman Stensgar. Really appreciate it. And we wanted to next at least introduce briefly and say hello to Assistant Secretary Larry Roberts and Deputy Special Trustee Deb Dumont, who are also on the phone call with us today. I wondered if each of you maybe just had a brief hello or a few comments, and then your discussion is going to come a little bit later in the webinar.
Great. Good afternoon, everyone. This is Larry Roberts, and I just want to first thank all of the tribal leaders that are on the call today for participating in this fantastic webinar that NCAI has put together. And I want to say thanks to NCAI for inviting us to be part of the discussion. And I really look forward to working with everyone to implement this law. I think, as Chairman Stensgar put forward, it is an exciting law. It's been something decades in the making, and we're excited to move forward on consultations within the next couple of weeks here, and I'm going to touch upon that further in my remarks later. So I just want to say hello to everyone, and thank you for being involved in this discussion this afternoon.
And over to you, Deb.
Thank you. Yeah, this is Deb Dumont here, and I want to thank NCAI for inviting OST to participate on the panel today. It's certainly energizing to listen to our tribal leaders' vision about self-governance in the future, and this new act, the Indian Trust Asset Reform Act of 2016, certainly provides new opportunities and real important steps for tribes to control their destinies and exercise their sovereignty. And we, too, are very happy to be part of the conversation and the dialogue and look forward to the next steps.
Thanks so much, Deb. And now we're going to go over to Brian Gunn. Brian Gunn's a member of the Colville Tribes, and he is an attorney who's worked on this legislation a great deal, very familiar with the details. Many of you may be familiar with Brian, but I'll turn it over to you, Brian, and to give us more of a detailed explanation of the new law and what we can expect.
Well, thanks a lot, John. Yeah, again, Brian Gunn. I'm a member of the Colville Tribes. I'm from Washington State. I was lucky enough to have been able to work with Vice Chairman Stensgar, AT&I, and some of the other tribes who were behind this effort that ultimately led to Public Law 114-178. I've got about a little over a dozen slides, and I was hoping to go through them fairly quickly just to be respectful of the Assistant Secretary's time. He mentioned that I've got another engagement in about 45 minutes. So why don't we, Colby, just get started with the first slide. Just as an overview, the law that we're talking about is the Indian Trust Asset Reform Act. The underlying legislation was H.R. 812. That was the House bill. That was the version that was signed into law by President Obama on June 22nd. And there was a Senate companion bill, which was S-383. The 812 was sponsored by Congressman Mike Simpson from Idaho, and the Senate companion was sponsored by Senator Crapo, also from Idaho. I think there's three key points that I think it's just important to mention really at the outset. And part of the reason is that some of the reporting that's been done on the bill or the law since it was signed, has kind of referred to earlier versions of the bill, maybe the one from the last Congress, but there's been a little bit of confusion on some of these points. So I think the very first thing is to emphasize that the bill, what's in the law, is entirely voluntary for Indian tribes and Indian beneficiaries. If tribes and beneficiaries don't want to see the status quo changed whatsoever, nothing about this law being in effect will change any of that. It's all voluntary and opt-in. The second thing is, and this is probably the most critical, is that the law as written does not impose any restructuring on the Department of the Interior, BIA, or OST. In one of the previous versions of the bill in the last Congress, there was a title that used the word restructuring, but as passed into law, it affects no structural change on any of those entities. And the third, and this is probably the most important, is that as written, the law does not sunset or terminate the office of the Special Trustee. I'll talk about that in a little bit more detail in the next slide, but just at the outset, just know that there's nothing in this bill that causes the termination of the office of the Special Trustee. As Vice Chairman Stensgaard mentioned, the bill was really about a decade in the making. Much of the text, I should say, originated from S-1439 and H.R. 4322 in the 109th Congress about a decade ago. As many of you recall who kind of worked in this area, Senators McCain and Dorgan had put forward a bill called the Indian Trust Reform Act of 2005. And that bill actually had a hearing on March 1st, 2006, but ultimately didn't move, didn't really see much movement other than the hearing. The bill at the time had a provision or a title that would have settled the Cobell case. And, I think most observers, that title made the overall bill a little bit more difficult to move. As the settlement was announced and went through the various approval process, the AT&I Trust Reform Committee began updating the text of S-1439 about 5 years ago. And in updating it, we really focused on two titles of the decades-old legislation, which was the Indian Trust Asset Reform Demonstration Project and the title that dealt with the Office of the Special Trustee. As this developed and as we came up with a draft, the AT&I Trust Reform Committee ended up blessing a draft in late 2012. Congressman Simpson introduced it at the end of the 112th Congress, and in the 113th Congress it was reintroduced as H.R. 409 and in the Senate as S-165. Now, this is, when I was mentioning about former versions of the bill, this is pretty important. H.R. 409 and S-165, as introduced, would have terminated the office of the Special Trustee within 2 years of enactment. And that text essentially carried forward from S-1439 in the 109th Congress unchanged. So, there was a prior version of the bill that would have terminated the office by a date certain, but, in response especially to the administration's position on the bill at the hearing in that Congress, a number of revisions were made to the bill based on administration, congressional, and tribal and Indian beneficiary feedback. And the version that was signed into law does not do that, does not terminate the office. and that version again was introduced by Mike Simpson and Senator Crapo in early last year as 812 and S383. So there are really three titles to the new law. The Title 1 is Recognition of Trust Responsibility, the Indian Trust Asset Demonstration Project title, and then the third title, which is a hodgepodge of a few different things, which is called Improving Efficiency and Streamlining Processes. So we'll just go through the titles sort of one by one. The first title, Recognition of Trust Responsibility, it's essentially the congressional findings, and there's a Section 102 that reaffirms the United States' responsibility to promote self-determination regarding government authority and economic development. These weren't intended to be sort of operative parts of the bill, but we did want some findings in there. And what I will say is that this title did undergo significant revisions from when it was initially introduced in the 112th and 113th Congress to the version that was signed into law. And much of that had to do with the administration's comments and the committee's comments about the potential effect on federal liability. But ultimately, we ended up being pretty happy with how Title I turned out. So Title II of the bill is, or the law, is really the operative center. What this title does is it authorizes trust asset management plans to the Secretary that will essentially guide federal management of the resource, or if the tribes want to do it themselves, tribal management. Really the difference in this authority compared to 638 or self-governance is that instead of essentially getting money from the department to act as a contractor to carry out federal functions, what tribes can do in these management plans is really change the substantive management of the resources. So just in terms of applying, the title lays out what's needed in an application. Once it's submitted, the Secretary must act within 120 days of the tribe submitting the draft plan. And it's really a shall approve model with these plans. So within 120 days, the Secretary must approve the plan unless any one of the three circumstances listed there are present. So we wanted to make it kind of as user-friendly as possible for tribes that were interested in going this route and not have a lot of delay and not sort of allow the department or not allow the department, but not give a lot of extraneous criteria that could delay approval of these plans. If for some reason the department were to disapprove a plan, then judicial review is available. And even though it's called a demonstration project, in our view, this title is essentially permanent because the demonstration project can be extended by the discretion or at the discretion of the Secretary. And then finally, there's no limit on the number of participating tribes. So any tribe from anywhere in the country, no matter how many, can submit these plans. In terms of the plans themselves, one of the big components of them is that tribes, when they submit these draft management plans, they can waive federal regulations in those plans. And the law does not limit the regulations that can be waived to what's in Title 25 of the Code of Federal Regulations, or the regulations that the Bureau of Indian Affairs administers. So arguably, any regulations that are out there that relate to trust assets or management of trust assets can be waived in whole or in part as part of the submittal of these plans. Now, the plans themselves can't violate federal laws or statutes, but if you have a regulation that's not prescribed by an underlying statute, then those are all sort of in the discussion to be waived. So, I just list a couple here in the slide, a couple of ideas. Park Service, BLM, Fish and Wildlife, any of those regulations that relate to trust assets in any way potentially, again, can be included in these plans to be waived. And I think really for oil and gas tribes, who deal with other besides the Bureau of Indian Affairs. This is something that I think they could potentially benefit from the most. A couple of other points, just there's no resources that are excluded from the scope of these plans, so it's non-monetary resources. Even trust funds are potentially includable should a tribe want to submit a plan that includes those resources. And then finally, Title II also includes language that extends the Hearth Act authority for forest management activities. Most folks on the call probably know the Hearth Act allows tribes to adopt tribal regulations governing surface leases that are consistent with federal regulations. And if they do that, then any regulations or any leases entered into under those regulations don't require review or approval. The same is going to be true here for forest management activity, National Indian Forest Resources Management Act.
Hey, Brian, this is John. I was going to just interject briefly here and suggest that, I think this area of tribes developing their trust asset, resource plans is, the ball will be in the tribes' court. This is work they'll have to figure out how to manage. I guess I was wondering if you or any of your clients are already working on these, and we've been thinking about the idea of maybe information sharing among those tribes who are interested, so they can, I suppose that this is a new kind of thing. Nobody's developed these trust asset this particular type of trust asset management plan before. That some information sharing among the tribes might be helpful. So we hope to do that with this work group. The people who signed up for this webinar, we're going to try to share information with you in the future as tribes start to do this, and maybe they're drafting up plans. They can maybe share ideas on how to get the work done.
Yeah, that sounds great, John. One right now related to forestry, but it's really kind of what tribes want to make them, I think. I mean, the scope of potential resources are vast, and it may be that tribes simply want relief from one aspect of a management regime, while other tribes may want to have it done a completely different way. So, my guess is that the initial plans that are generated will probably be all over the map, but I do think as a repository for these plans would be very helpful. So I think we're on to the next slide. So Title III, improving efficiency and streamlining processes. This is sort of the hodgepodge title that I mentioned at the beginning. The main part of it is it authorizes the Secretary of the Interior to establish an Undersecretary for Indian Affairs. Created would report directly to the Secretary, and is really intended to coordinate and supervise other activities that go on within the department vis-a-vis BIA. One of the reasons for this provision is that it was intended to make sure that we thought that it was important to have a position that was able to ensure that Indian Affairs was sort of in the other land management agencies at Interior. I mean, I think we saw a number of cases where initiatives that would be started by other land management agencies would get pretty far down the road before Asia found out about them or was in a position to comment on them. So this is really intended to make sure that whatever the Indian agenda is at the Interior Department is that there's somebody essentially keeping watch on it for the components that affect Indian country. The other thing to know is that this provision is not or this new Undersecretary authority, if it's created, is not intended to displace the Assistant Secretary or the Special Trustee. So it's a new position, a new high-level position. And then once the position is established by the Secretary, it's to be appointed by the President with Senate confirmation. Next slide. Title III also requires the report to Congress on the Office of the Special Trustee. And as the slide here suggests, within 1 year, There's a report that the Secretary needs to submit to Congress that describes various information related to OST, including a transition plan for OST to terminate within 2 years of submission, or an alternate date if an orderly transition cannot be done within 2 years. This provision was really kind of a compromise on our end, in the sense that we knew that the department would not support a bill that terminated OST by a date certain, and we knew this from our experience with HR 409 in the last Congress. But we also wanted to kind of tee the issue up for discussion with Indian country. And so we thought that the best way of doing that was to simply have an informational report that tribes, individuals, and Indian organizations were able to comment on and help shape, and essentially have that report be submitted to the policymakers for further action or no action. So the bill itself states that the report is informational only. There's explicit language that nothing in the report causes OST to terminate, nor does it affect the application of the existing provisions in the 1994 Act that relate to the sunset of OST. The bill, the 1994 Trust Reform Act that created the office, contains a provision that allows the special trustee to submit a report that essentially certifies that the major trust reforms have been implemented, and then within a certain number of days after that submission of that report, the office terminates. So there already is in the existing law sort of a self-termination provision for the office, and the report that we're talking about in this new law is not that report. This is simply an informational report that doesn't set anything into motion. Our view was that consultation, the kind that the department is embarking on this month on this issue, is really going to be an important opportunity for tribes to weigh in on this in a focused manner, because the issue has been around for about 2 decades now. The other part of Title III is appraisals and valuations. 2 components to this. The first is that there's language in the law that says within 18 months, the Secretary shall ensure that appraisals and valuations of trust property are administered by a single bureau, agency, or other administrative entity within the department. This provision is not intended to isn't intended to cause any kind of wholesale shuffling of appraisal functions, but it is intended to get at one issue that we've heard about continuously, and that is the 2 separate bureaucracies being involved in the preparation of appraisals. So currently, the Bureau of Indian Affairs is responsible for accepting or gathering appraisal requests from tribes and beneficiaries, and then transmitting those requests to the Office of the Special Trustee. And so once OST gets the request, they then either do the appraisal themselves or contract out to have someone else do it. The problem is that if BIA doesn't transmit the request or it doesn't get done in a timely manner, the appraisal just never gets done. And because they're 2 separate entities, there's really not a way of knowing, other than just kind of bird dogging it, really knowing where an appraisal is in the queue, at least from the tribe's perspective. So what this provision is simply intended to do is to make sure that whatever entity does the appraisal, whether it's OST or some other entity, that they get the request in the first instance and don't have to rely on another agency to send it to them. Next slide. Okay. The other appraisals provision deals with minimum standards. So the bill also provides that the Secretary, within a year, shall establish and publish minimum qualifications for individuals to prepare appraisals and valuations of Indian trust property. And once those standards are published, when an Indian tribe or an Indian beneficiary submits an appraisal that satisfies those standards, essentially no further review or approval is required, and the appraisal is considered final for purposes of completing whatever transaction it was required for in the first place. So what this is really intended to do is to eliminate the review appraisal step in the process, which we've heard from a number of tribes, was unnecessary time. So the other component to this section is that in order for tribes and beneficiaries to have an appraisal treated this way, they have to affirmatively opt in. We didn't want to have a situation where somebody mistakenly submits an appraisal and it's done, it's considered complete without their knowledge. We wanted to make sure that there was some affirmative action that was needed on behalf of tribes and beneficiaries to opt into this. But we also think that this will go to great lengths to eliminate delay or perceived delay that tribes and beneficiaries have told us about when trying to sell or lease trust land. So at least that's our hope anyway. These are just some final thoughts and observations, but before that, there is one last section to the bill that I didn't do a slide on, but I'll just explain. And that's section 206, which deals with cost savings. That section basically says that going forward, if there's any function or activity of the Office of the Special Trustee that will no longer be needed, whether through any kind of consolidation or any kind of further action of the department, that the Secretary needs to identify what that cost savings would be and send that information to the Tribal Interior Budget Council, which is, as many of you know, is the advisory group that advises the department on Indian budget issues, so that the TIBIC can provide recommendations on how that money will either be reallocated or moved around in the budget. So that was intended that if there was future restructuring, whether by Congress or by some future administration, that if there is cost savings, that Indian country would have a say in how that money gets reallocated. So that was section 206. Just some very final thoughts and observations here on this last slide. The trend, having worked on this bill for a few years now, especially with the committees of jurisdiction, the trend really seems to be less bureaucracy, not more. I think we can all agree, at least on our end, that, or the advocates' end rather, that the Undersecretary will provide a new opportunity for Indian country in the next administration in terms of coordination and being on the front end of policy initiatives in the department. And this is my opinion, but it's also the opinion shared by some of the folks close to working on this bill, that the core accounting and investment functions that OST performs, really need to continue uninterrupted. I think that was one of maybe the sources of misinformation, is that the bill would get rid of OST and that all of the accounting functions that work smoother than they did 30 years ago would go away. That's not, again, what the bill does, and that was never the intent. In fact, what we have said is that those functions really need to continue. Where they're most appropriately housed in the department, I think is going to be a discussion for tribal leaders and beneficiaries to weigh in on in the upcoming consultations. But, in our view, we don't think that there's any question that those functions need to remain. And then finally, perhaps goes without saying, but the consultations can provide an opportunity to reassess how the department provides trust services to tribes. And I would add not just to tribes, but also to beneficiaries as well. So John and Colby, that's what I've got. You can maybe switch it over to Larry.
Yeah, thanks so much, Brian. I know that Larry Roberts, we're very glad to have him with us, and he doesn't. You've got to get going in about 15 minutes, so we thought we'd turn it over to you, Larry.
Great, thanks, John, and thanks again for Vice Chairman Stensgar and other tribal leaders for working so hard on this legislation and getting it signed into law by the President. For those of you that I haven't met before, I am a citizen of the Oneida Nation, and I've been leading Indian affairs since his departure at the end of last year. We are very excited about moving forward to implement the law. As I'm sure many of you heard, either myself or Secretary Jewell or others talk about the views of this administration, self-governance and self-determination is our North Star, and as Brian went over the law that was passed, there are a lot of elements there in this law. I'm going to focus my comments primarily on Title III. I think that that is the department's initial focus. Hopefully, every tribal leader has received a letter that Deputy Secretary Connor sent out in July 13th of this year, providing notice on the consultations that we're going to be holding beginning next week and running through the month of September. We're excited about those consultations. We're going to be focusing on the aspects of Title III for two purposes. One is the law provides for the department to issue a report within 1 year of the passage of the act, which is June 22nd, and so given transition issues for the next administration, and knowing that there's always a ramp-up time in transition, our goal, or the Deputy Secretary's goal, is to issue that report during this administration, so that when the next administration comes in, there's not a steep learning curve on all this work. And so we are going to be seeking input specifically on the functions of OST and whether they should be transferred to other entities. If so, a transition plan and a timetable on how those functions might move. As Brian mentioned, the law providing for a transition of all appraisal services to a single entity, seeking obviously input on that. The draft, we're going to be proposing minimum qualifications for individuals to prepare the appraisals, and this is one thing that we've been working on quite a bit internally. Our hope is that within a relatively short time period here, we will be issuing a proposed rule about those minimum qualifications. I don't know whether that proposed rule will be issued before our first consultation or not, but we will be making available essentially a draft of that rule if it's not published, so that tribal leaders have an opportunity to really look at what's being proposed and discussed, and then we will get it published as soon as we can for the proposed rule, and we'll have a time frame then for further comments on that. The idea is that I think that, as Brian said, this is something that Indian country had been asking for, and it's something that hopefully we'll get a lot of tribal support for in the comments on a proposed rule as we move forward. So that's something that we could hopefully get across the finish line as well. And then I think obviously we will be seeking input from tribal leaders on the establishment of an undersecretary for Indian Affairs. And I know in my meetings with tribal leaders since the bill has been passed, there's been questions and thoughts in terms of where does for example funding for that office come from, who's paying for that sort of thing, and where it fits exactly within the department. And so we're looking forward to receiving tribal input on that as well. And so I guess I would just close and turn it over to Deb by saying, we're really, we have a consultation schedule here that's going to touch upon all areas of the country. It's going to be a number of agencies within the department participation, so it'll be OST and BIA and someone from the Assistant Secretary's Office for Indian Affairs, and I think the Deputy Secretary will be attending some of the consultations as well. And so we're looking forward to it. We're looking forward to the dialogue with Indian country, and as we work on preparing this report. So So with that, I will turn it over to Deb.
Thank you, Mr. Roberts. Again, this is Deb Dumont here, and on behalf of OST and the Special Trustee, Mr. Vince Logan, the staff here today and those working throughout Indian country, just want to let you know it's certainly a privilege to serve you and to be a partner in the government-to-government relationship. As Brian explained, Title II of the Act, providing for the tribal demonstration projects, is a significant milestone. With the passage of the Indian Trust Asset Reform Act, specifically to Title III, Congress is also requiring the Secretary of Interior to identify the functions that OST performs, which is an opportunity for us to reflect upon our current practices and chart a path forward with Indian country to continue the improvement of the stewardship of trust assets as well as in support of the tribal sovereignty. It's also an opportunity, as Brian mentioned, to reflect on the Department's progress in trust reform since the passage of the American Indian Trust Fund Management Reform Act of '94. OST was established in response to tribal leaders demanding accountability and transparency for the Indian trust funds. And as a result of the tribal leadership and congressional oversight hearings, a number of corrective actions were identified to assure the proper control and accountability for the trust funds management. And Congress created OST to improve that accountability and management of the Indian trust funds and the overseeing of the coordination of reforms within the department. And we've made great improvements on the initial functions of receiving, dispersing, treasury reporting, and investment and trust functions that were transferred to OST and tagged by secretarial order. Between 1996 and 2007, we've had additional responsibilities for financial trust fund management, such as appraisals of Indian trust lands, and the historical trust accounting operations were also delegated to OST. As some of you know, OST manages over $5 billion in trust funds. We use a modern centralized fiduciary accounting system for tribal and IIM funds, which includes the collection of funds, investing, disbursement of trust funds to individuals and tribal beneficiaries. We've received and dispersed approximately $1.9 billion each year for more than 400,000 individual Indian money accounts and 250 tribal trust accounts. And OST created an integrated system of core trust accounting related to support functions and offices in order to fulfill the fiduciary obligation under the 1994 Reform Act, and also maximizing service delivery to the beneficiaries. Some of those functions, really briefly, include the creation of the Office of Trust Records and the American Indian Records Repository, the AIR, located in Lenexa, Kansas, to ensure the proper safeguarding and storage of fiduciary trust records. The creation of the toll-free trust beneficiary call center to provide direct support to the Indian trust beneficiary calls and inquiries. The creation of field operations staffed by our fiduciary trust officers and regional trust administrators to provide the direct beneficiary account support services, as well as partnering with BIA in addressing trust matters. And also, we know the value, of OST comes from its position within, doesn't come within its particular position within the department, but rather, our singular focus and discrete duties focused on the fiduciary trust responsibilities. Moreover, these duties must continue no matter in which office they're located. So we do look forward to working with all of you to implement the Indian Trust Asset Reform Act and welcome the dialogue with Indian country. We have posted to our website, www.gov/OST/ITAR, the functions, OST functions, and we've also posted the description for each function to assist with the tribal consultations. The OST management of the non-monetary trust resources is the appraisal program consultation, and we'll be posting items on the web become available. As Mr. Roberts mentioned, that there is potentially a proposed rule, and whether that will be available or not depends on how much work we can get done. But Section 305A of the Act requires the appraisals and valuations of Indian trust property to be administered by a single entity within the department, and we have 18 months to do that. So Brian's interpretation is very helpful, and hopefully you get those comments because when you look at appraisals, Office of Appraisal Service, we do a lot of the surface appraisals, but BIA Forestry also provides the timber appraisals, and then the Division of Mineral Evaluations provides the minerals. So there are other entities, and where that one entity should be located within Interior will be up for discussion during the consultations. And we'll continue to post to our website. Again, that's the www.doi.gov/OST/ITARA. It's in the Dear Tribal Leader letter identified. And also, if Kobe, if you could put back the consultation slide, because it has been updated. And the Federal Register has also been revised with the locations. But I think we need to note August 17th at Green Bay during the Indian Land Working Group, that is a listening session. And as far as I know, only OST will be there. We'll be certainly taking comments from beneficiaries and also tribal leaders. That is a listening session. And then the next consultation, August 22nd, will be in Albuquerque. The following consultation, though, is, if you look at the Dear Tribal Leader letter of the Federal Register, August 26th in Minneapolis, and you have Seattle here. And also August 31st, then will be Billings. September 7th will be Osage Event Center. September 9th is Sioux Falls. September 12th is Palm Springs. So we'll just need to update.
Thanks, Deb. Maybe what we can do is after the webinar is over, perhaps we can send an email out to all the participants in the webinar that would do two things. One would be that this website that you mentioned sounds like a great resource, and then an updated list of the consultations.
Right. Just want to make sure folks are, we put this together very quickly. We know that the time is coming upon us shortly here, and just want to make sure we have folks in the right place. But yeah, August 29th, I think, is the one error that I see there just on the site, just to bring to everyone's attention.
Thank you. That's very helpful.
Great. And then, we're going to have a steady set of consultations. I'm sure as we get comments, we'll be able to maybe revise some of our presentations, to make it helpful. But for us, clearly, getting input early on from tribal leadership on what they would like to see, what would be helpful in the presentations, and what we can post. We'll certainly have copies of the handouts. The presentations that we'll be providing will be available during the consultations. And then again, we'll direct folks to the website. But, in the meantime, the OST staff, they're continuing to work hard to serve Indian country and to certainly meet our mission critical function during this time. So if there's any questions for me, let me know. Certainly, again, appreciate the time to be able to participate and have real meaningful consultations.
Thanks, Deb. Maybe we should go to questions and comments from our participants in the webinar. Two ways to do that. One is you can type questions into the box if you have a question over on the right, or you can click on the button and raise your hand, and then Colby can unmute your line, and then you can just talk to anybody on the webinar. Does anybody have a question or a comment from our webinar participants today?
John, we have a first question from Casey Nichols, who posted in the question box asking, what are the advantages/disadvantages to this act compared to the HARP Act?
That sounds like a Brian Gunn question.
Yeah, sure. Good question.
Brian, sorry to interrupt you. Unfortunately, John, I am going to have to sign off here. But I just want to say thanks for the opportunity to participate, and looking forward to seeing tribal leaders during the consultations as we're moving ahead next week.
Thank you so much, Larry. We really appreciate it, and we'll be seeing you soon.
Bye-bye.
Yeah, so Brian Gunn here. So just in addressing the question, the advantages and disadvantages versus the Hearth Act, I would say that the demonstration project or the trust asset management demo project in Title II, it's different than the Hearth Act because with the existing Hearth Act, you can essentially a tribe can enter into surface leases without needing departmental approval. With the demo project authority, a tribe would be able to lay out tribal priorities, substantive tribal benchmarks or priorities for how they want, let's say, timber or grazing, and those can deviate from federal regulations. So it can really be the tribe's own, substantive standards as opposed to the United States. So that's probably the main difference. In terms of advantages, I mean, this bill or the law does extend Hearth Act authority to forest management, so it basically borrows the exact model of the existing Hearth Act and simply transplants it over to forest management. So I don't know if one is necessarily better than the other as much as they are just different types of authority. That's how I would answer that question.
Brian, maybe I could ask a follow-up question. I recall back in the, Vice Chairman Stensgar started us off with this discussion of the old Trust Reform Task Force days and when we started working on this legislation a long time ago. And I remember there was this discussion, tribes may have different priorities for how the available resources are used. And an example of that we used to discuss a lot was the problem with prairie dogs in the Great Plains, that a number of tribes had these tremendous issues with prairie dogs taking over large sections of land, and they wanted more resources focused on prairie dog management. Do you think that these trust asset management plans could be used in those types of situations to sort of refocus the resources on problems as the tribes perceive them?
No, John, that's a good question, and the answer is yes. When you look at the law, one of the items that a tribe needs to include when submitting a draft plan for approval is, how they might want existing funding sources prioritized or reprioritized to accomplish the management objectives. So that type of model is something that went into our thinking in putting the Title II together. So no, the short answer is yes. I mean, another example that we used is again in the realm of tribal forestry. For folks on the call that they're from reservations where there's forest management going on, the Bureau of Indian Affairs has a certain minimum allowable cut for most reservations that they strive to meet, which is a certain number of thousands of board feet that need regardless of what the conditions are. For example, a tribe had one of these plans, and let's say that the tribe wanted to have part of their reservation forest to be kind of left alone and untouched for tourism or other types of reasons. Then they could write a plan that articulates that requirement in the management and have that be something that would be part of their management plan. So again, sort of deviations from how what this authority was really intended to do is allow tribes to deviate from the substantive management practices that the Bureau or the Department adheres to currently in managing trust assets.
Thanks, Brian. So Colby, you have any other questions?
No other questions submitted yet. Again, as John said, you can type in questions into the question box and submit them that way. You can also click on the hand button, which has a green arrow on it, to raise your hand, and that way we'll be notified, and then we can make your microphone live and you can ask your question. Does anyone else have any questions?
And Colby, this is Deb. I would just add that in the Federal Register, my contact information is also provided. And as folks are reviewing our material, if they have any questions, feel free to contact me.
Well, I guess we'll just wait for a moment or two and
Okay. We have a question. Oh, sorry, John. We have a question submitted by Dan Raybear via the questions box. He asked, what is the difference, if any, between the listening session and the consultations?
This is Deb. I'll answer that question. At the listening session, OST will be participating, and I don't believe our Asia representation at that particular one. All the other consultations we will, but the listening session we were asked by the Indian Land Working Group if we would participate and host one, and we agreed to do that. It was pretty short timing. We will be taking down comments that will be submitted for the record. We won't have a court reporter at the listening session, but there will be a court reporter at all the consultations. Does that help answer the question?
Yes, I think so. We have another question in from Naomi Stacy. And Dan says, yes, thank you, that answers his question. Naomi Stacy asks, is this bill just for tribally owned trust lands? Is there application to priorities in federal plan or in management plans of federal agencies?
This is Brian. I'll take my best shot at answering the question. I mean, it's really directed towards tribal trust resources, I would say. So wherever tribal trust resources are located, those resources could be included in the management plans in Title II. I think that in terms of other federal land management agencies planning documents or management plans, I think that if you have a tribal trust resource that for whatever reason or whatever the circumstances are is covered by a management plan or regulations from another non-BIA agency, those types of practices, if there are regulations that can be waived, those are things that would be includable as well in a trust asset management plan for that resource. So I think the short answer is that it's going to depend on where the trust assets are located, and if they're located in an area where there's sort of additional layers of non-BIA agency regulations that apply to them.
Okay, great. Thank you, Brian. Does anyone else have any other questions? Okay, we have a question from Christine Myers. Are there existing templates or examples of tribal trust asset management plans?
That is an excellent question. Again. Go ahead, Brian. I was going to turn it over to you, but this is the one where I've been wondering, how we could at least start to think collectively about, sharing information as tribes start to develop work on this subject, that we could share possibility.
I certainly don't know of any that have been approved. I mean, there may be tribes that are working on some. I know that I'm working on one now. I guess I don't know of any that have been approved as of yet, but hopefully, sort of with NCAI's sort of tutelage here, we can have NCAI kind of act as a repository for willing tribes to sort of share their plans that they've submitted or approved. So I guess I'm hopeful that in not too long we'll have multiple plans for folks to look at and compare notes on. I mean, I personally think that it would be good for an oil and gas tribe to do one, because I think that would be a good template for other tribes that have those resources that are currently navigating other non-BIA agency regulations. So I guess the short answer is no, but hopefully not for long.
Great, thank you, Brian. Does anyone else? Oh, we have another question from Christy Myers. Can you suggest preliminary elements for the outline of such an asset plan or asset management plan?
Brian here again. I guess I would start really with what's in Title II. It's when you look at the law, it is Section 204. Section 204 is what lays out the contents of what the plans must include. And just for benefit of folks on the phone, one is that you have to identify the trust assets included in the plan. You also have to establish trust asset management objectives and priorities for each of the resources. You also have to allocate trust asset management funding for the particular management that's desired. You have to identify whether the tribe intends to carry the management out itself or have the department do it under like direct service type of an arrangement. You also have to establish procedures for non-binding mediation or dispute resolution. And then there's a couple of other things. But I guess I would start with just taking a look at Section 204 of the Public Law 114, 178. And that's where the core requirements for the contents of the plans are listed.
And this is John. I guess I was going to add that there's another broader issue about planning more generally that's been coming up in a number of other contexts, that tribes often, they get funding for transportation, or they get funding for housing, or they get funding for different sort of trust responsibility areas, education, but there often isn't more comprehensive planning dollars available. So how did the transportation and the housing all work together with the economic development and jobs on the reservation? I think our hope was to have at least some discussion leading into the transition plan and the next administration about trying to increase the funds that are available to tribal planning departments so that they can do more comprehensive planning, and also this type of trust asset management planning. I mean, basically all the trust land on an Indian reservation, whatever it's used for, whether it's a school or a hospital or timber, I mean, that's all a trust asset. And potentially these trust asset management plans could include a very broad range of activities on the reservation.
Okay, great. Thank you, Brian and John. Our next question is from Lori Wendell. Do you have any plans for training federal DOI employees and agencies on the initiative and its implementation? I guess this would be for Deb.
This is John. Just a quick, I think the first shot at that is going to be at these consultations where, I don't know if it's training, but at least it's dialogue between federal officials and tribal leaders. And then it'll, and Brian mentioned this earlier, but I think he's probably right that, given that there's maybe less than 6 months left in this administration, and this will be rolling out, probably over the next year or two, we're probably really going to be working with the next administration, whoever that is, to really implement the new law. We'll just be getting it started. And so there likely will be a big need for education during the transition to the next, the next administration.
And John, this is Deb. Just to clarify, the consultations are on Title III, and certainly we'll take comments on Title II, but the presentations are limited to Title III. We did see the Title II as more of a, as Brian pointed out earlier, voluntary tribe by tribe, and the department, I'm sure, will be at some point in time providing additional guidance, but that isn't something currently on the agenda or published in the Federal Register. So just for clarification.
Okay, great. Thank you. Does anyone else have any questions at this time? Again, you can type them into the questions box or raise your hand. I can unmute your line.
And if any of the tribes participating, some of you may already be thinking about trust asset management plans, and maybe your planning departments are working on it. We'd love to hear from you and talk more about how we can work together on that, and how tribes can. It's likely we're at the beginning of a process where the tribes will be spending a lot of creative energy coming up with new trust asset management plans, and sometimes it's really helpful to just have discussion groups and share information on that kind of stuff.
This is Brian Gunn. One thing that I'll mention about the plans themselves is that we wanted to have the substantive requirements for submitting a plan to be as clear as possible in the statute itself. We didn't want to have require the department to do regulations to implement the management planning part of the law, just simply because we didn't want things to slow down. We wanted to have it be, as direct and user-friendly as possible for tribes to submit these plans. So I do think that, once plans start coming in, there will be a bit of a learning curve for the BIA or whatever officials that review these plans or establish a review process for these proposed plans. But, we wanted to, one of the questions that I've gotten is, will there be regulations that implement Title II? And our intent was no. Obviously the department can do regulations if it wants to, but we didn't want to require regulations as part of this law, just simply because we wanted things to be able to move as quickly as possible.
All right. Did you have any more questions come in, Colby?
No other questions so far.
Okay. Well, if there's, of course, if any last-minute questions come in, we'd love to answer them, but maybe we should start wrapping up. I think we'll try to send a follow-up email to all the webinar participants with a link to the website that Deb Dumont here mentioned, and also with an updated list of the upcoming consultations. And in response to that, please get in touch with us. If you're working on these issues or have any more questions, we'd love to provide all the assistance we can. And I guess that's about it. I'd like to thank Larry Roberts, who's already left, and Deb, thank you so much. Also to Vice Chairman Stensgar and to Brian. We really appreciate you helping us out today, and we'll look forward to working with you more as this issue moves down the road. Thanks very much, everyone.
Thank you.
Thank you, John.